It's making weird noise. So yeah, so it's being recorded now. So today we will discuss about, as I told you guys in the last class, we will discuss about equity jurisdiction. Okay, so rest I hope is quite clear to you guys. Apart from, I didn't give you guys many definitions of equity because I don't think those are very important. Okay, if you just study, for example, Aristotle's definition, which I told you guys earlier about, that will suffice in understanding of what equity is essentially all about. Apart from that, you have other thinkers as well. So those thinkers will be Henry Maine has said in something, Snell, the book that I have referred to. Then Blackstone has also said certain things. So you have many other definitions to definitions given of equity. Now, history, I think I dealt in quite good detail, and you can always relate that to our other, previous discussions in, CLS classes. So yes, these are, I think most of the topics are covered so far, which are of relevance here. So today, then we will gradually proceed to this topic of classification of equity jurisdiction. Now, when we talk about classification of equity jurisdiction, what we are essentially talking about is the different kinds of situations, okay, when the when equity will be applied, okay, when the law of equity will be applied as of now. Because as you know, in the last class we discussed that post 1873 and 1875. Sorry. মই মাংসু কোৱা চাইছো মই আহি আছো ৰবা এটা ক্লাছ আছে ক্লাছ কৰি আহি আছো ৰবা so we were in the earlier class we were discussing about how these jurisdictions were like merged. Okay, so after 1873 and 1875, now the same sets of courts apply both law of equity as well as common law or other laws. Okay, so what happens essentially now is that you do not have separate court that has only equity jurisdiction, but you have same court that that could have jurisdiction under common law as well as under law of equity. I'm talking about England. Our case again is a little different than that. So what essentially is now the case is that now that the same set of courts have equity jurisdiction as well. So those equity jurisdiction can now further be classified into three different kinds, okay, three different categories. Okay, so this is something which was first, which was propounded by Judge Story of in the United States of America, and Strahan, another jurist, who has also categorized this more specifically into three different criteria. Okay, three different types. Okay, so these are the three different kinds of cases, as I just told you, where the courts interfere in the name of equity. Okay, courts interfere in the name of equity. Now, as you remember, earlier we tried to define what conscience is. Okay, so earlier the chancellor has wide jurisdiction. Wide, what should I say? Power, like very broad power to interfere in the name of conscience. Okay, but later on in the 18th and more specifically in the 19th century, we see that all those equitable matters were more ossified, more categorized, and now in only those situations could anyone interfere. Okay, now those specific situations can also be are specifically the ones that can broadly be categorized into three different criteria. Those are exclusive jurisdiction, then you have something called concurrent jurisdiction, and the third kind is auxiliary jurisdiction. So am I audible to you guys? Can you hear what I just said?
Yes, sir.
Okay.
Yes, sir.
Okay, so you have three different kinds of jurisdiction then. Okay, you have first one called exclusive jurisdiction. The second kind is concurrent jurisdiction, and the third kind is auxiliary jurisdiction. The names are themselves like self-explanatory. They tell you what those effectively mean. Okay, so this classification was made by Strahan. Okay, now a preliminary introduction as to what these different jurisdictions are like. Okay, so the first one is exclusive jurisdiction. Okay, as the name itself says, okay, these will be the matters in which only the court of equity provides you, recognizes the rights as well as provides you the remedies. Okay, as the name itself says, these are exclusively within the jurisdiction of within the equitable jurisdiction of a court, if I use it properly for today's context. Okay, so these are exclusive equitable jurisdiction of the court under equity. So what are those? Those are essentially those matters in which common law gave you no right. Okay, if you were to appear before a common law court earlier, before this merger, if you were to appear before a common law court, there will be no recognition of such right. Okay, there will be no recognition of such right. Okay, but court of Chancery back then would have recognized this in the for the protection of the conscience of the king. Okay, so this is what it would have been earlier, but as of now, these are the rights which are not recognized by the court under common law, but are recognized by the court under law of equity. So is the first kind clear to you?
Yes, sir.
Okay. So then you have the second kind. Okay, the second kind is where the court exercises this jurisdiction, equity jurisdiction, and it is little different than the first one. Okay, and this one's known as concurrent jurisdiction. So as the name itself says, okay, so these will be the cases in which on the same matter, both the common law court earlier, both the common law court as well as the court of equity would have exercised jurisdiction, and hence we call it concurrent jurisdiction. And as of now, after the merger, the same matter will be dealt with by the court under common law as well as equity. Okay, now there's a distinction though. Why would the same court be dealing with the same matter in two different ways? Okay, the reason is quite simple. Okay, so unlike the previous case where there was no right recognized, okay, here the right is recognized by the common law court, under common law. Okay, but the remedies which are provided to you under the common law are not sufficient. Okay, so the remedies which are provided to you under this are not sufficient. Okay, insufficient remedies. So remember, equity essentially does complete justice. Okay, complementary or complete justice. So if you need complete justice to be done to you, then you also seek this kind of remedies. Okay, in addition to the remedies provided to you under the common law. Okay, so these are the cases of concurrent jurisdictions. I have a question. Okay, I will. I'm not recording here, but I'm recording on another platform. So yeah, I will upload it. For fear that I'm not able to access it. So yeah. So anyway, where was I? I think concurrent jurisdiction. Yes. So the third kind here is auxiliary jurisdiction. Okay. Now what is that? In the third kind will be the cases where you have both right as well as remedies under the common law. Okay, third kind will be the ones in which you have both rights as well as remedies under the common law. So what's the issue then? So under this case, even the remedies are fine. If provided to you, the remedies are fine. You will be satisfied. But there are certain defective processes, okay, to secure those remedies, okay. In order for you to achieve those remedies, the procedure which are provided by the common law are not sufficient, okay. So sometimes it could even affect the right that you are claiming, okay. So you will not be able to prove the right in itself, okay. Then how would you will you be able to achieve those remedies, okay. So to remedy this particular defect, okay, in the process, okay, uh, a different kind of jurisdiction will be exercised by the court under equity jurisdiction, whereas in earlier cases the same thing will be available to you under the from the court of equity. But as of now, the same set of courts but under equity jurisdiction. So that's how broadly we can classify equity jurisdiction into these three different kinds, okay. Am I clear so far?
Yes, sir.
Okay.
Yes, sir.
Okay.
Yes,
Okay.
sir.
Okay, then I will proceed. Then I will explain each of them with little more detail, so that with examples it will be clearer to you. Okay. Now let's start with exclusive jurisdiction. Then, so how did I define it? So exclusive jurisdictions are those in which certain you are claiming a right, you go before the common law court, you seek a particular right, but the court says that under the common laws, under the existing laws, you do not have such rights, so forget about remedies, the right itself is not recognized, okay. So but then you think that you are entitled to certain right, okay, but that right you cannot claim under the law, but you can claim it before the court under court of equity, okay, in the name of conscience earlier, but now they have become specific rights under the law of equity. So I hope you understand the distinction, okay. Earlier it will be decided based on the conscience of the chancellor, now they have become specific rights under the law of equity. In Indian context, for example, anyway, the examples that I'm going to be giving you right now will be sufficient anyway. So yes, so those rights will be available under the equity, okay. So now because these rights are recognized by the court of equity, they will also provide you the relief, okay. This relief will then again be not available under the common law, because under common law you do not have a right. So if you do not have a right, where is the case of remedy? Because under the equity this right has been recognized, the remedies will be also provided under equity and not under common law. So understand the distinction. This is very essential, because we quite often mix these two up, okay. So certain examples will make this thing clear for you. So for example, you have trust property and beneficiaries property rights which are recognized under the, for example, in our case, Indian Trust Act, okay. But trust is something which has been codified now. Historically, trust property, or the idea of trust relationship between trustee and beneficiary, did not exist, okay. Common law only recognized ownership, okay, under common law, okay. And so what if there were certain other kinds of rights which were not recognized by the common law? What happens then? So those rights were recognized by court of equity. So trust being the best case. So what happens in case of trust? Again, through an example maybe I can explain to you. So trust essentially means reposing faith in someone. Now faith is not something, or trust, confidence is not something which is protected under the common law. This is something which is a matter of conscience, okay. So hence protection under equity. Now what happens in trust is that, so for example, you want to transfer certain property in favor of someone else when that person becomes of certain age, okay. So meanwhile you do not want to transfer the property to that person, okay. So what you can do is you entrust the property in favor of, for example, person A, and then you say that with this condition that when the person B comes of age, becomes major, you then transfer the property to that person. Meanwhile, that person B will have certain beneficial interest as against the trustee, that is person A. Now what would happen back then, okay, would be that only the first transfer, okay, first part of the transfer, that you transfer the property in favor of A with the condition that it be further transferred to someone else on certain event, or that certain other beneficial interest be provided to that person. The second part will not be recognized by the common law, but only the first transfer will be recognized by the common law. Okay. Now all the beneficiaries' rights will not be recognized by the common law court. Now if the beneficiary were to approach the common law court will say that there is no right. The transfer has happened from, for example, me to A, no transfer in favor of B. So that right will not be recognized by the common law court. Okay, but that right was subsequently recognized by the Court of Chancery, and which further crystallized into specific trust, property known as trust property, and under that you have beneficiaries' rights as well. So all those ideas of property emerged out of this particular jurisdiction, which was exercised by the Court of Chancery earlier, and now the same rights have been crystallized. So law of trust is very specific right now, but this comes under the law of equity in England, whereas in India we have codified that under the Indian Trust Act. So is the first example good enough for you to understand the distinction and understand what exclusive jurisdiction is all about?
Yes, sir.
Okay. There is another kind of property. Okay, so I'm giving you English example. Then we will take up our Indian case later on when we look at different maxims. Then we will look at some of the Indian examples will be provided here as well. Okay. And when you study trust, okay, so subsequently when Ishrat sir teaches you trust, you will have better understanding, easier understanding of how trust actually works. Okay, so for example, when we talk about what are the rights and duties of a trustee, and what are the rights and duties of a beneficiary, okay, all those things will be better understood by you if you understand how the idea of trust, as I tried to explain to you, had emerged from the equitable jurisdiction of Court of Chancery. Okay, so remember this in mind, and the next portion will be much easier for you. So yes, the next kind of situation where exclusive jurisdiction was exercised was the case of married women's property. So in England earlier, okay, prior to 1873, I guess, I'm not sure, you have to check, okay, in the 1870s, something like that, okay, prior to that, married women, did not have her own property. So her property would essentially be her husband's property, okay. Yes, Ashutosh, did you join later? Did you hear what I said at the beginning? I'm doing that. But the problem is that, I do not... okay, I'm typing it. So yes, what I'm saying is that, yes, so another example would be married women's property. So prior to 1870s, I think 1873, I don't remember the exact date. So prior to that, married women's property was not recognized. Her property would be considered as her husband's property. But the thing is that Court of Chancery, okay, so for example, when a situation arose where the husband divorces the wife, and then wife will be left high and dry and she will have nothing to fall back on, okay. So in those situations, so although under common law there is no such property right recognized of that of the wife, under the Court of Equity's Court of Chancery, under its equity jurisdiction, the women's right to certain property will be recognized. Okay, so am I audible to you guys now at this stage?
Yes, sir.
Okay.
Yes, sir.
Okay.
Yes, sir.
So to some of you, I might not be audible. Do not worry. I'm recording it, but not on Drive, but on my PC, and as and when it is ready, I will upload it. Do not worry about it. But then you be here in the class, because I'm taking your attendance this whole time. So be here. Do not leave. Be there. Even when I'm not audible, be there, because I don't want you guys to lose your attendance. I don't know, there might be technical issues and all that. I don't want you guys to. I will share the attendance from today onwards on this platform, so don't worry. So yes, that's another example. Other examples will be, so for example, you might have heard of equity of redemption, the doctrine of equity of redemption. Okay, so in case of English mortgage, okay, in English mortgage, what happens? In English mortgage, it's more or less like trust, isn't it? So you, for example, it's a case of security, isn't it? So you borrow some money from someone, okay, and in lieu of that, what do? You transfer your property, certain property, okay, in that said person's name, okay. Now what happens is that you are to pay the money within a certain period of time, okay. You are to pay the money within a certain period of time, okay. So when you pay the money back, okay, so the person, the other person supposed to transfer the property back to you, okay. So the moment you pay the money, you do not have the property right, because you have already transferred the property, okay. So you do not have a property right under the common law. So this right will not be recognized by the common law court, okay. So what will happen then is that once you have made the payment back, now you have a claim to that property. So that claim comes under equity, and that right is known as equity of redemption. So you will go to the court and insist that your property is, transferred back to you under equity. If the same is not done, okay, that will be done, okay. But if it is not done, so you have a remedy under the law of equity. But if you were to approach the court of common law earlier, okay, before merger of jurisdiction, that property right will not be recognized by the court of common law, okay, because such conditions of further transfer was not recognized by the court of common law. Another situation might arise, okay. So for example, you are to pay the money, okay, by certain day, but you fail to do that, okay. You fail to do that. What happens then? Does the other person still becomes the owner of the property? So sometimes what happens is that even if that were the contractual stipulation, okay, even then the court of Chancery compels the other person to transfer the property back to you if you agree to pay the money back to that said person, okay. So this is the case of equity of redemption. So this right was not, this equity of redemption, the second part of transfer, okay, which is to be made back to you, was not something that was recognized by the court of common law earlier, but was only recognized by the court of Chancery. And now those jurisdictions are merged, and the same court is exercising both these under the different laws, common law on the one hand and then equity law on the other. So that's another example. Then another example is conversion. So you might have studied what conversion is already in, I think, in your Transfer of Property Act, maybe I think you have studied this, okay, because this is essentially is all about transfer of property. Have you studied conversion, the doctrine of conversion? If you have, then I need not explain, here. Have you guys studied the doctrine of conversion? Am I audible?
No, so we haven't.
You haven't? Okay.
We have not, sir.
So you might have, but you probably don't know what it is. So I will explain what it is, okay. You must have, it's not possible. If you have studied transfer of property, you have studied. I will explain, then maybe you will be able to relate, okay. So in conversion, essentially what happens is that, so for example, this is like, related to transfer of property as well as contract, because both laws are applicable here, okay. So what is it? It's this. So there are two ways, okay, properties could be transferred, okay. So you either transfer the property altogether, okay, following proper procedure, okay, you through proper conveyance, registration, everything is done, okay, all the legal necessities under the Transfer of Property Act or Indian Registration Act and all others are followed, okay. So that's a valid transfer, okay. Or you could do something else. You could under a contract. Okay, you can enter into contract that you will transfer the property, the said property, on a certain day. Okay, so in the first case there is a transfer of property. In the second case there is what? A contractual agreement. Got the idea? So what happens then is that the moment you have, in the second case, okay, in the second case where you enter into a contractual contract, say that okay, you will be transferring the property subsequently. Okay, so what happens then is that your proprietary right in rem, okay, with respect to the property becomes proprietary right in personam. Okay, why? Because the person in whose favor and with whom the contract has been entered into, and if you are the owner of the property, from now onwards you have a property right, but that property right is in personam with the other person. Okay, got the idea? In personam with the other person, because you are the owner on the face of it. If it were under the common law, they will say that you are the real owner of the property, but under the law of equity, that other person will have most of the features of being the owner. Okay, so what do I mean by that? So for example, you cannot further transfer the property to others, because the property you have entered into a contract with someone else to transfer the property. And subsequently, for example, if any damage, or there is a fire on that property, certain damages happen, the person with whom you have entered into contract to transfer the property, that person will bear the cost of it. Okay, so that's the idea of conversion. So what was proprietary right in rem becomes proprietary right in personam. Okay, so here in this particular case, whose right is recognized? So the person with whom you have entered into contract, that person's property rights are recognized, not under the common law, but under the law of equity. So these are certain examples of cases, okay, in which exclusive jurisdiction, okay, so certain rights which are not recognized by the court of common law, okay, or under common law in today's context, will be recognized under the law of equity. So is that clear so far? Did I explain all these examples well enough for you to understand?
Yes, sir.
Okay. Okay. So if that's the case, then I will proceed to the next kind of jurisdiction. Okay. So the next kind of jurisdiction is concurrent jurisdiction. So what happens in case of concurrent jurisdiction is that here it is not a case where no rights are recognized. Okay, rights are recognized. Okay, but remedies are not sufficient. Okay, remedies are there, but those remedies are not sufficient. So this is essentially based on that maxim called where there is a right, there is a remedy. Okay, ubi jus, ibi remedium. Okay, so this is essentially that maxim. Okay, applied in a certain way here. We will study this maxim later again. Okay, so what happens is that common law court recognizes certain rights. Okay, but you are not satisfied with the remedy which is provided to you. Okay, so rights and remedies do not commensurate. Okay, so although you could sue in the common law court for the said right, it will recognize that right, but the remedies that will be provided to you are not sufficient. You're not happy. The conscience will also not allow. Conscience will require that much, something else be done, something more be done. So in such case, you will seek remedy as of now under equity. Okay, earlier you would have to go to a different court, that is the court of chancery. Now you seek the same remedy but under law of equity. Okay, so what happens is that certain remedies are provided by the common law court, certain others are not provided, but those certain other remedies are very essential for complete justice. Okay, so that's why equity steps in. Okay, so here's I'm going to refer to this earlier critique, whether common law and equity are in conflict or they are in contradiction. In the first case, in the case of exclusive jurisdiction, there apparently is no contradiction. Why? Because this is a completely new kind of right which is recognized. So where is the case of contradiction? in this particular case also, we can say that equity and common law work hand in hand. Okay, so there is no contradiction. Why? Because what the court under its equity jurisdiction is doing is not negating the rights, okay, the remedies which are available to you under the common law, but providing you certain additional remedies. So it is not a case of, as Snell and others would say, a case of contradiction. Okay, so this is the second kind of jurisdiction, okay, known as the concurrent jurisdiction, in which rights are recognized by the court under common law, and remedies are also provided to you under common law, but those remedies are not sufficient. You need additional or different remedy, okay, remedy in addition or in lieu of the remedies under common law. In such case, you seek different kinds of remedy under the equity, under the law of equity. So that's the kind of jurisdiction that we call as concurrent jurisdiction. So there are many examples for that. Okay, so the first will be, so for example, what could happen that one of the remedies which is quite often provided to you would be compensations or damages provided to you by the common law court. Okay, compensation or damages provided to you by the common law court. Okay, so specifically in the case of contract, where damages are provided to you by the common law court as a remedy, but you are not satisfied with it. Okay, so what you essentially want is for the other party to specifically perform this part of the contract. Okay, so that remedy will not be available to you. So you have a remedy available, that is damages or compensation, but you are not satisfied with that remedy. Yes, any confusion?
Sir?
Oh, Chitrakshi, yeah. Tell me.
Sir, can we also approach the courts of equity in criminal matters?
I am so far referring only to civil matters. Okay, criminal matters are different. Okay, so far I am referring to only civil matters. Okay.
Okay. Thank you.
I will give you examples of very limited cases where the same can be applied, but not like this, in a different way. Okay, you can use the words equity, good conscience, and all that, but these are so far all civil matters. Okay, so try and follow me. I will tell you when questions of criminal matters also come. So what we see here is that that the remedies which are provided to you. See, so far I haven't given you a single example of criminal matters, all civil matters. The moment anything is related to criminal matters, I will tell you, don't worry. So, what are those? So, you need specific performance of the contract, but there is not a remedy which is available to you under the common law. So, you seek the same from the court of equity earlier and now under the equitable jurisdiction of the same court. Okay. Apart from that, there are many other things. So, for example, you want to maintain status quo, okay, while a particular matter is being decided, okay. So you can also seek injunction. So all these things, okay, you will find under the Specific Relief Act in India, okay. So the same thing has been codified into law in India, okay. Now here's something. There might still be something, okay, which the court can do in the name of justice, equity, justice, good conscience, beyond what is provided to you under the Specific Relief Act. Okay, that is still within the power of the court. Okay, in a limited way. Okay, so yes, apart from that, you have other examples. So, for example, rectification of documents. Okay, is another thing that you might have already studied under. If you have studied Specific Relief Act, or registration will be taught now, so you haven't probably studied this. Okay, so for example, a deed is created, okay, a sale deed is created, of a particular piece of property, but quite often it is possible that there is no meeting of minds between the two parties. Okay, so the same can be fixed. Okay, same can be fixed through rectification of documents. Okay, the same and that is available to you, so a specific remedy which is available to you under the equity jurisdiction. Now in India, you find it under the statutory laws. So Indian Registration Act Section 17 deals with that, and Section 26A of the Specific Relief Act deals with rectification of documents. Apart from that, you have another thing called set off. Okay, when you have so these are basically suits relating to recovery of money. Okay, so someone's suing you for the recovery of money, but what happens is that you being the defendant here, you claim that it's not counterclaim, it's a claim for set off. Okay, that the other party also owes certain amount of money back to you. So basically, the amount which is owed to you is be set off against what you owe to that other person. Okay, now so that there is no multiplicity of suits. Okay, to reduce all that. Okay, so this is something which will not originally was not available to you under the common law, but now but then the same was available under the equity. Okay, the same has been inscribed in Civil Procedure Code Order 8 Rule 6. Okay, so you probably have studied this as well. So there's nothing new I'm talking about here. Apart from that, when a contract is entered into, okay, if it was based on fraud or mistake, again there is no meeting of mind. Okay, so outcome will not be satisfactory, so remedy will not be proper here. So you want the same matter to be dealt with in the light of these new claims. Okay, so fraud and mistake. So the same again has been codified in Indian Contract Act. Okay, so what is voidable contract, all those things you might have already studied. So all those grounds of void or voidable contract, okay, were basically an outcome of this specific jurisdiction of the Court of Equity. So in all this, I hope you guys understood what concurrent jurisdiction essentially is in all this matter. So what happens is that your rights are recognized, but in the light of certain situation, certain because of certain other matters, okay, the remedies which are provided to you are not satisfactory. Had certain other facts been taken into consideration, the remedy would have been different. Okay, which the common law court is not able to take into consideration. So you bring those to the notice of the court under equity, and now the remedy which is provided to you is sufficient and adequate in the light of those additional facts. Okay, so that's the concurrent jurisdiction of the Court of Equity. Okay, now here's the thing. Okay, the remedies which are provided to you will be provided to you under this jurisdiction only if certain kind of remedies are already available to you under the common law. If no remedies whatsoever with respect to that matter are available to you under the common law, okay, and no right is also recognized under the first jurisdiction, exclusive jurisdiction of the Court of Equity. If those rights are not recognized, then no remedy will be provided. So there cannot be, as of now, invention of a new remedy which is non-existent under the common law. So if common law provides you certain remedies and those remedies are not sufficient for you, then only additional remedies will be provided to you by the Court of Equity or court under the equity jurisdiction. So in this case by the name Cole versus Home of Colonial Stores Limited, it was said that where the matter is within the concurrent jurisdiction, an equitable remedy could be granted only where legal remedy would lie. So equitable remedy will be available only where you have legal remedies, but you are not happy with the legal remedies, hence you are seeking additional equitable remedies. If there were no... Yes?
Could you please repeat the name of the case?
Coll, C-O-L-L versus Home and Colonial Stores Limited. I will share this with you. Don't worry. Just follow me for now. So what had been said here essentially is this, that if there is a legal right, only then, legal right has to be there. You have to have legal remedy as well. And then if you're not happy with the legal remedy, then you can also ask for equitable remedy. But now they are very much codified. So anyone who's approaching the court will seek both kind of relief. Okay. that's subject to your choice though. So certain relief might be available, you might want them, you might not want them, so it's up to you whether you want that remedy or not. So that thing still exists. Okay, so this is the concurrent jurisdiction. So in this particular case that I mentioned, what had happened essentially is that there was some kind of interference with the enjoyment of light. Okay, the enjoyment of right to light. Okay, now the interference was not so much as to be considered as nuisance under the common law. Okay, so if it was a nuisance under the common law, then there will be certain remedies available to you under the common law. Now what happened was that in this particular in this particular case, someone had interfered with the enjoyment of right to light of someone, but it was of not such a nature so as to, it has to be continuous and other kind of certain other necessities are there, for which only then will it be considered as a case of nuisance. And if it were considered as nuisance, you will have certain remedy under the common law. But the thing is that it didn't fulfill the requirement of it being considered as a nuisance. So when the person appeared sought a remedy from the court of equity, remedy of injunction was granted, but injunction was granted even when there was no remedy recognized under the common law, because the right itself was not recognized. So when the matter was ultimately taken to House of Lords decided that no, this remedy will not be available because the first right was not recognized and there was no remedy under the common law. So in the complete absence of right, whether under common law or equity, and then whether in the absence of complete absence of remedy under the common law, no additional remedy, no other remedy can be recognized under the under the law of equity. So I hope you guys understood the second kind of jurisdiction. Is it clear?
Yes, sir. Yes,
Okay.
sir.
So I think
Yes, sir.
so before you guys go, okay, I will stop this recording first.